of business is request for bill introductions. Do we have any requests from committee members? Yes, Senator Bowers.
Thank you, Madam Chair. I do have a bill and an RS number. It's RS 2720, and it's creating an exemption to certain mandatory reporting obligations for licensed social workers.
Thank you. And with that, then, that request is approved for introduction. Any others? Not seeing any. Do we have any requests for bill introductions from the audience? Yes, we do. Please approach the podium, introduce yourself, and welcome to committee.
Thank you, Madam Chair. Committee members, Ed Klump. These requests, I have two of them, and they're both on behalf of the Kansas Sheriff's Association, Kansas Association of Chiefs of Police, Kansas Peace Officers Association. The first one is, I guess one of them is for all three of those. Let me back up here a little bit. The first one that's for all three of the associations is RS 3177. That's 3177, and it deals with our law enforcement background statute, making some amendments to that.
All right, that request will be approved for introduction.
And Madam Chair, my second one is on behalf of the Kansas Sheriff's Association, and that one is 26 RS 3164, and it deals with the software we use and the process we use for tracking registered offenders.
Thank you, and that request will be approved for introduction.
Thank you.
Thank you. Any other requests for bill introductions? Yes, please introduce yourself and welcome to committee.
Thank you, Madam Chair, members of the committee. Good morning. My name is John Gidier with the League of Kansas Municipalities, requesting introduction of 26 RS 3039, and this deals with competency evaluations in municipal court.
Thank you. The request is approved for introduction.
Thank you, Madam Chair.
Thank you. Any others from the audience? Not seeing any. So thank you then. Our next item of business is a opening hearing on Senate Bill 373, creating a maximum length of time for an agreement between a utility and law enforcement to install law enforcement equipment on a utility pole or structure. And with that, a bill brief from the reviser.
Thank you, Madam Chair. Senate Bill 373 amends a provision that you put in place last year, KSA 60-5402. This statute provides public utilities with immunity from liability for actions that arise from an agreement with law enforcement to install equipment on utility poles or other structures that are owned by the utility. This section is amended to prohibit a public utility from entering into an agreement with law enforcement to attach, access, operate, maintain, or remove law enforcement equipment on any utility pole or other structure owned or operated by the utility for more than 30 days, unless authorized by a lawfully issued warrant, court order, or subpoena, or the utility pole or structure is in a public area zoned for commercial activity or in any park or recreation area that's operated by a municipality, as defined in KSA 12105A. You'll see at the bottom of my bill brief that I copy and pasted that definition so you can see what classifies as a municipality. After 30 days, any equipment has to be removed from the utility pole or structure, and any evidence that's collected after that 30 days shall not be admissible in any legal proceeding. The immunity provision that you put in place last year is amended to require those public utilities to comply with this new subsection A in order to get that immunity from liability. And I can take any questions.
Thank you. The immunity from liability, is that page 1 in line 27, that remains in place as long as they comply with subsection A?
Correct, Madam Chair. You'll see starting on line 23, this is the provision that you guys put in place last year, but you'll see we added in italics there in line 29 that in order to get that immunity, it has to be an agreement that complies with the requirements of subsection A that you're putting in place here.
Okay, I think you said line 29, but you meant 27.
Oh, 27, I'm sorry.
Okay, as I'm looking at it, thank you. Committee, any other questions for the reviser? Not seeing any, then thank you. Appreciate it. Committee, we do have a number of in-person conferees for today. So I'm going to allow 20 minutes for proponents and 20 minutes for opponents. And so you can divide your time as you see best to use. And we'll try to go to make sure that everyone has an opportunity to be heard. So our first proponent conferee today is Bob Stewart, Executive Officer, Kansas Bureau of Investigation. Please introduce yourself and welcome to committee.
Madam Chair, members of the committee, good morning. Happy Kansas Day. My name is Bob Stewart. I'm the Executive Officer with the Kansas Bureau of Investigation. When we first saw this bill, we looked at one particular part of it that very much is exactly what the KBI is interested in that we use. And that's what I want to talk to you about and sort of explain a little bit today as quickly as I can. And that regards what we at the KBI call poll cameras. Poll cameras are a specialized investigative technique where we have an open investigation over where we believe that a crime is being committed, and we are putting a closed-circuit TV camera, no audio, on a lot of times a utility pole, sometimes on private property, aimed directly at our target, aimed directly at a residence or a business where we believe criminal activity is taking place. That is, of course, as you all understand, governed mainly by the Fourth Amendment. When we use that technique, sometimes we have probable cause, and when we have probable cause, we can use a little bit better camera, and we can look at places that maybe aren't publicly available under judicial authority. When we don't have probable cause, we fall back on the general theory that is there a reasonable expectation of privacy in what we're looking at? When there's not a reasonable expectation of privacy, for example, the front door of a residence or the front door of a business, we don't feel like we need judicial authority, and our policy indicates that. So what we would do is set up a camera in a public place where people have the right to be, aimed at the front of a business or the front of a residence in order to determine what kind of criminal activity is moving in and outside of that business. The reason we do that is a lot of times, especially our sophisticated criminals, are aware of law enforcement surveillance. I'm aware of cases, particularly in Wichita and in the Kansas City area, but it can also happen in rural areas where law enforcement presence is noted very quickly and behavior changes. Bad guys hide better when they know we're around. They change their activities. It makes it harder for us to prove a case. So, and it can be dangerous. As you all know, 4 law enforcement officers in the state of Kansas have lost their lives in the line of duty in the last year. None of them have been ambushed on surveillance, but we are aware as law enforcement that across the country, there are times where law enforcement officers have been assaulted and killed while they've been conducting surveillance activities. So there are times where this technique not only is an efficient and effective technique, but it's a law enforcement safety technique. We had a case in Wichita where some of our drug dealers were on a cul-de-sac. They not only were operating their drug operation out of a home at the end of the cul-de-sac, they had a building at the front of the cul-de-sac that was, or a residence at the front of the cul-de-sac that was owned by them, and they were keeping a lookout. So if law enforcement was moving at all into that area, it was difficult to sort of do any surveillance other than by poll camera. So I would also kind of point out that it is becoming a more limited technology. Our bad guys, especially our sophisticated bad guys, are aware that this is a technique that is being used. So they're using counter surveillance techniques and making it harder for us to even use this technique. It's becoming more expensive. Even though last year you limited liability from the utility companies, we are still observing increased fees from the utility companies both to install and to remove the device. And of course, it's more expensive now for us to even monitor those cameras with our own personnel. When it comes down to trial, we certainly have obligations under discovery to turn these over to the defense. That costs money for them to review them, so we're getting downward pressure from the judges to limit this technique as well. So while it's still a valuable technique, it's becoming a more limited technique from our perspective. That said, we believe that the spirit of this bill comports or follows along with what the KBI policy has been and what we believe the district courts in Kansas and the 10th Circuit Court of Appeals federally have determined is appropriate use. So we understand the spirit of the bill. We do have several suggestions that we noted when we were reviewing the bill. The first one is it doesn't appear in the language that the KBI is included in the definition of law enforcement. We suspect that's a drafting error and that you wanted to include us in the definition of law enforcement. Second, we note that in the language of the bill, it indicates that we can use this technique for 30 days. That certainly comports with current KBI policy, but there are situations, as I mentioned, where occasionally we are in that window where in that first 30 days, we've used the technique, we didn't have probable cause, but now we have probable cause. And we want to make sure we've got the ability then to turn around and get judicial authority after that and get continuing 30-day windows if we need them, rather than just a shut 30-day window. If there's then judicial authority that we can go back and get what we call re-ups for continued 30-day periods. We would like to see that language. The third thing, and I know that you'll have a bunch of testimony about this as well. We think that we would strongly recommend that this not be inclusive of license plate readers, not be inclusive of shot spots and all the other sorts of cameras that might be put on for long-term purposes, for public safety reasons, and for license plate reader reasons that this bill should not apply to. So we would ask that you consider an amendment in that regard. And finally, I noticed something this morning, and while I've been a prosecutor and I've been an agent, I've never been a defense attorney, but occasionally I think like one. And I was looking at the 30-day window, and I would wonder if it would be appropriate for language to indicate exactly when that 30 days starts and stops. Because without that, a defense attorney might come in and say, well, 30 days from the time you got authorization, or 30 days from the time of installation, or 30 days from the time the KBI first turned it on. So if you could clarify that would make it helpful to us. I will limit my comments to those remarks, and I stand available for questions at the chair's convenience.
Thank you. Yes, and we'll take questions at the end. Next, we will hear from Samuel G. McRoberts, Litigation Director, Kansas Justice Institute. Please introduce yourself and welcome to committee. And we have about 13-ish minutes left. Thank you.
I will not use all 13 minutes. My name is Sam McRoberts. I am Litigation Director at Kansas Justice Institute. That's a pro bono law firm. We litigate Fourth Amendment cases, among other types of cases. As a little bit of background, long before this bill's introduction, given our concerns with poll cameras, ALPRs, shot spotters, facial recognition, we did begin conducting open records requests for policies from municipalities and law enforcement agencies regarding the use of these types of law enforcement techniques or tools. I can appreciate and understand why law enforcement wants to use poll cameras, ALPRs, and other types of technologies. What I think is important to consider is that those technologies raise very serious constitutional issues. I was incredibly happy that the KBI acknowledged that these do raise Fourth Amendment issues, and in fact, they do. There is case law that talks about long-term surveillance on a person moving around. Their freedom of movement does create a Fourth Amendment issue. I think that the most important part of this bill is that it's not banning the use of poll cameras. It's not banning the use of ALPRs, but what it's doing is subjecting those technologies to judicial oversight, which I think is entirely reasonable. That is how law enforcement has worked for hundreds of years. If law enforcement is going to use these things, then a judge must sign off on them. I think that's reasonable, and I think that is a very good common ground instead of just outright prohibiting these types of things. I made a couple of suggestions in here. I would not recommend, I didn't know the ALPR issue would come up today. I would not recommend this court this body removing that from this bill. I think that's very important. The reason I say that is based upon my review of the open records requests. Once that data goes to a law enforcement agency, there are agreements to share that information among many law enforcement agencies. So if one agency has it, they could give it to a different law enforcement agency. They can give it to different states. They can give it to different federal agencies. And presumably they also have those types of agreements. So if one law enforcement agency has it, it can be shared widespread. And I think that is a major problem, especially in the context of ALPRs. Because now what you're doing is you're giving precise location data and movement data to hundreds, if not thousands, of different law enforcement agencies. So for all of those reasons, I think it's just important to make sure, which is reasonable, that a judge signs off on this. And that's all this does. Thank you.
Thank you. Appreciate that. Next, we will hear from Logan DeMond, ACLU of Kansas. Please introduce yourself and welcome to committee. And we have about 10-ish minutes remaining.
Thank you, Madam Chair. My name is Logan DeMond. I'm the Director of Policy and Research at the American Civil Liberties Union of Kansas. We're happy to be here today in support of Senate Bill 373, which we believe is a much-needed response to House Bill 2109. I'll be brief this morning, focusing on our concerns with previous legislation, and then discuss our recommendations for this as well. House Bill 2109 poses a significant threat to civil liberties and obviously brings up major Fourth Amendment right concerns. Even if erected on public utility poles, a camera can directly or indirectly surveil private property. And when law enforcement can initiate warrantless long-term surveillance at their own discretion, innocent bystanders' sensitive information risks being exposed. Additionally, people have a reasonable expectation of privacy in their home, and long-term surveillance of one's home violates Fourth Amendment rights to be free from these unreasonable searches. Even in the case of law enforcement targeting a specific individual, that individual's activities and their associations can be surveilled and collected without a warrant under this law. Ensuring a warrant is in place provides an additional layer of protection from unjust, warrantless, state-sanctioned surveillance. Now, moving on to our recommendations, I want to start out by saying that we appreciate the added amendment of lawfully issued warrants, court orders, and subpoenas outlined in this bill. We do, however, believe that the exception for polls in public areas or parks should only apply if the areas being monitored are also public. Private businesses and other entities should not be subjected to unknown surveillance, and neither should the individuals entering or exiting those spaces. We believe that an amendment in committee could easily remedy this and address these concerns. So in conclusion, we believe that this is a step in the right direction. And by adding the suggested amendment and passing this bill out of committee, the committee would satisfy the concerns of the ACLU of Kansas, our civil liberties concerns here, and concerns regarding the Fourth Amendment. Thank you for your time, and I will stand for questions at the appropriate time.
Thank you. Appreciate it. Next, we're going to go ahead and make sure our opponents are heard, and then we can open it up for questions. So first of all, are there any other persons in the committee meeting room or on WebEx wishing to testify as proponent on the bill? Not seeing any, then we will open it up to our opponent conferees, 20 minutes, and we will first hear from Captain K.C.D. Slaughter, Wichita Police Department. Please introduce yourself and welcome to committee.
Thank you, Chair, and members of the committee for the opportunity to speak today on behalf of the Wichita Police Department regarding Senate Bill 373. I'm Captain Casey Slaughter, representing the Wichita Police Department in Wichita, Kansas. The department strongly opposes this bill because it would significantly restrict lawful, effective, investigative tools that help us reduce violent crime and protect our community. I want to begin by clarifying how these tools are actually used. Poll cameras and license plate readers are not deployed casually, and they are not used without accountability, but they are also not all used in the same way. License plate readers do not track people. They capture license plates in public spaces. Courts across the country have consistently held that their use does not violate the Fourth Amendment. In Wichita, LPRs are deployed based on crime data and patterns, not discretion or curiosity. Their use is governed by strong policy, mandatory training, and robust auditing. Every query is logged and reviewable. While LPR deployments do not involve prosecutorial oversight, they are tightly controlled through internal safeguards and accountability measures. Poll cameras are different. They are placed only in public locations where anyone could lawfully stand and observe the same activity. They are deployed based on reasonable suspicion and specific investigative needs. In complex federal drug or firearms investigations, poll camera use often includes prosecutorial oversight, particularly through partnerships with the U.S. Attorney's Office, In those long-term cases, investigators work closely with prosecutors, supervisors, and legal counsel with regular communication and accountability. However, not all poll camera deployments require or involve prosecutorial oversight. There are situations such as ongoing criminal activity in a public park, at a known chop shop, or at a location generating repeated calls for service, where a poll camera is necessary to monitor activity, identify offenders, or confirm whether criminal conduct is occurring at all. In those cases, deployment is still governed by standard operating procedures, supervisory approval, and documentation, but not necessarily by a prosecutor. Over the past 5 years, our WPD narcotics commander has been involved in long-term investigations with prosecutorial oversight, where poll cameras were deployed for 12 to 24 months. Those investigations resulted in more than 100 convictions or guilty pleas, the seizure of over 1 million fentanyl pills, hundreds of pounds of narcotics, and hundreds of illegal firearms. Those outcomes would not have been possible under the 30-day limit proposed by this bill. The reality is that complex criminal investigations do not operate on short timelines. Artificial time limits do not protect civil liberties. They protect criminal enterprises by preventing law enforcement from identifying full networks, suppliers, or victims. If the concern behind this bill is misuse, guardrails already exist. Officers are trained, use is documented, supervisors review deployments, audits occur, courts can suppress evidence, officers can be sued, disciplined, or lose their certification. Existing criminal penalties for intentional misuse would be far more effective than eliminating the tools themselves. The appropriate response to misuse in enforcement is enforcement and accountability, not the elimination of a tool that protects the public and solves serious crimes. I also want to briefly address cost. Since new requirements took effect last July, we have invested $55,000 in training, safety certification, equipment, and infrastructure and we've created a dedicated poll camera position using existing staff, which is already limited. These investments reflect our commitment to responsible use, but they would be largely wasted if the bill advances. It's also important to note that the cost I just mentioned does not include the cost of the poll camera systems themselves, which are exorbitant. On Monday of this week, the license plate reader system was instrumental in locating a homicide suspect, providing critical evidence needed to solve the case after the suspect fled the state within 8 hours of the offense. In closing, the Wichita Police Department does not ask for unchecked authority. We ask for reasonable constitutional tools that are already governed by policy, training, audits, and oversight. Senate Bill 373 would significantly hinder our ability to investigate violent crime and organized criminal activity. We respectfully ask the committee not to advance the bill. Thank you for your time, and I'll stand for questions when the time is right.
Thank you. Appreciate that. Next, we will hear from Sheriff Jeff Easter, Sedgwick County and Kansas Sheriff's Association. Please introduce yourself and welcome to committee.
Morning, Chair and Committee. I'm Jeff Easter. I represent the Kansas Sheriff's Association. I'm the current Sheriff of Sedgwick County. The Kansas Sheriff's Association opposes Senate Bill 373. First off, the bill is ambiguous, as you've heard already with some of the testimony from Casey Slaughter in reference to what cameras these actually apply to. We believe that it's applying to poll cameras, as Bob had talked about, that can be placed in an area in public view when we're trying to gather intelligence because we do not have probable cause for a search warrant as of yet. This particular bill would prevent us from doing that. And I can tell you that where I disagree with some of the testimony is that there is a ton of case law that's already there from the 10th Circuit and from the U.S. Supreme Court that makes it legal to do this, and I'll quote some of that. We already gather permission from the utility company to monitor high crime areas, drug-infested neighborhoods, and high traffic locations. Those cameras are mounted to only capture the public view, what you and I can see if we drive down the street. If we believe that there's probable cause to get a search warrant, to be able to put up a camera to look in behind a fence, those type of things that are protected by the Fourth Amendment, we already have to get a search warrant. When it comes to the 10th Circuit, has repeatedly held that poll cameras do not constitute a search under the Fourth Amendment. There is no reasonable expectation of privacy when the cameras are placed to observe what any other person could sit and observe with the naked eye. Additionally, attempts to apply the U.S. Supreme Court's decision in United States versus Carpenter have been unsuccessful. The 10th Circuit states that Carpenter's decision was meant to be interpreted narrowly and not to apply to all advanced surveillance tools. Carpenter has to deal with cell phones, which is a lot narrower scope when we do cell phone searches. In two 10th Circuit decisions, United States versus Jackson and United States versus Cantu, both from 2017, which is fairly recent, the courts determined no reasonable expectation of privacy. Poll camera surveillance is not a search. Warrantless poll cameras recording outside but not inside a residence do not implicate a homeowner's Fourth Amendment rights. United States versus Jackson is the binding precedent in the 10th Circuit, which we are in the state of Kansas. United States versus Katz from 1967, the courts ruled when a camera is capable of observing only what any passerby would easily see, have been able to observe, because activity a person knowingly exposes to the public is not a subject of Fourth Amendment protection, and thus is not constitutionally protected. In a case, United States versus Lucas in 2023 discusses curtilage, which is the outer property of the residence that's not blocked by a fence. It states, just because a poll camera captures footage of a residence, curtilage does not violate the Fourth Amendment. A poll camera on a utility pole does not constitute a physical intrusion. In California versus Cirillo in '86, same type of decision came out on curtilage. Finally, the United States versus Hay, a Kansas case from 2022, states, even prolonged surveillance does not violate the Fourth Amendment. In U.S. versus Hay, they discuss time periods and believe that 10 weeks or 68 days without a search warrant is feasible to have a poll camera conducting surveillance. So as you can see, there is a lot of case law that governs what we can do and how it can be done that's already established. And so for that, we ask that you not pass this out of committee. And I'll stand for any questions when the time is appropriate. Thank you.
Thank you. Appreciate that. Next, we will hear from Chief Daryl Atterbury, Bel Air Police Department, Legislative Committee Chair, Kansas Association of Chiefs of Police. Please introduce yourself and welcome to committee.
Hello, Madam Chair, committee. I'm Daryl Atterbury, and I represent the Kansas Association of Chiefs of Police. I'm here to convey our opposition to the SB 373. We feel the amendments that were made from last year's into this bill introduce unnecessary limitations that will hinder law enforcement's ability to protect our communities and uphold justice. SB 373 attempts to address an issue that's already fully covered under existing case law. Kansas law enforcement agencies operate under strict judicial review. You've heard that already from a number of people. And we have to meet constitutional standards when we're using the equipment. And I do want to add that this isn't just a poll cam bill. This is a police law enforcement equipment bill. So it's not just cameras. It's anything that is existing today or in the future that could benefit us in catching criminals that are victimizing our citizens would be affected by this bill. The safeguards that are in place ensure that searches are lawful, overseen by judges, and are fully compliant with constitutional protections. Adding another layer of legislation doesn't strengthen these protections. It only creates confusion and operational challenges for law enforcement. It's simply put, it's trying to fix a problem that doesn't really exist. You've heard a lot of comments about the arbitrary 30-day limitation. We believe that this is a problem because across the nation, law enforcement relies on surveillance cameras, license plate readers, gunshot detection systems, and those things are mounted on public utility poles often. These tools are vital for solving crimes, preventing violent crime, combating drug trafficking, and responding to threats against our public. And again, if something's visible from a public place, there's no general reasonable expectation of privacy. Sheriff Easter just touched on that. Several of the people who have spoken have touched on that. These devices that we use, especially license plate readers, they are focused straight on a public street, on a public thoroughfare. Yes, they're mounted on a public utility pole, but they're not looking at private property. And, you know, in some discussions we've had that these might be excluded from this. We would encourage that because these are such a vital tool for law enforcement today to help us solve crime. These devices don't invade on public space. They are placed, like I said, in public areas that have no reasonable expectation of privacy. And imposing that arbitrary limit to force law enforcement to repeatedly remove and then reinstall the equipment is a waste of resources, and it can create gaps in coverage where we could miss vital information. So if there's an established time frame in some case law, we would certainly want to abide by that, but I think any time limit is unnecessary. So law enforcement agencies already work within lawful agreements with public utilities for the equipment placement. It costs us money to put that equipment up, and it would certainly cost us to take that equipment down on the 30th day, only to maybe put it back up on the 31st day. These agreements don't require a search warrant because that equipment is not focused on private property. And I'm not talking about the poll cams for other law enforcement purposes. I'm talking about license plate readers. And even if that poll cam is placed on a public utility pole and it's not focused specifically on a residence or a business, and it's capturing things that you could see yourself if you were in that same location, we don't need a warrant. So in closing, the Kansas Association of Chiefs of Police suggests that SB 373 is unnecessary. It is confusing and possibly harmful for our communities, your constituents. Our current laws strike the right balance between protecting individual rights and enabling law enforcement to do its job. And this bill will not improve privacy protections. It will only impede justice and put Kansans at risk. And for these reasons, we oppose that bill, and I'll stand for questions at the proper time.
Thank you. Appreciate that. Next, we will hear from Matt Blassingame, FOP National Trustee for Kansas State Lodge Fraternal Order of Police. There's about 5-ish minutes remaining. Please introduce yourself and welcome to committee.
Good morning, Chair Warren, Vice Chair Titus, Ranking Minority Member Corson, and members of the committee. I appreciate the opportunity to be here and testify in opposition of Senate Bill 373. My name is Matt Blassingame. I'm the National Trustee for the Kansas Fraternal Order of Police. We do have a time constraint. We've had a lot of members, a lot of individuals speak in opposition of this bill already, so in order to not take up too much time, I have submitted written testimony, but I just want to say that the case law says that if we can legally be in a place, we can legally see in that place. If this Senate Bill 373 is passed, it will go against the established case law that's out there, and it will make Kansans less safe. So, thank you.
Thank you. Are there any other persons in the committee meeting room or on WebEx wishing to testify in opposition to Senate Bill 373? Not seeing any, then we will go ahead and have our neutral testimony as well before we open it up for any questions. We do have neutral testimony written only from Kimberly Svati, Kansas Municipal Utilities. Is there anyone in the committee meeting room or on WebEx wishing to testify as neutral on the bill? Okay, not seeing any, then we will go ahead and open it up for any questions. Senator Titus.
Thank you, Madam Chair. I think I would start with Mr. Stewart. Thank you, Mr. Stewart, for your testimony today, and I'm going to pick on you first because I believe you have a law degree, correct?
Pardon?
You have a law degree, right?
Yes, sir.
Yes, that's what I thought. So
Would you please go ahead and reintroduce yourself, yes?
Bob Stewart, Executive Officer with the KBI.
So I'll ask, I appreciate the case law, and I'll get to this with my next question to a different conferee, but as far as Kansas setting policy of deciding where we want the limits of protection on the Fourth Amendment and how we want to protect our citizens, there's nothing that violates federal law if we have stricter standards for cameras or searches or things like that under state law. Is that correct?
You're correct. No, there isn't.
Thank you. That's all I have for you. I wanted to get that out of the way. And then I have a question for Mr. McRoberts.
Sam McRoberts, Kansas Justice Institute.
Thank you, Mr. McRoberts. Appreciate your testimony today as well. One of the things you touched on this briefly when you talk about sharing data, but I know you've spent a lot of time thinking about the Fourth Amendment, and this is a little bit of a philosophical question, but one of the things that struck me when thinking about this bill, especially last year, is there are so many points of surveillance, right? It's in your public areas and every store and every Ring camera and every license plate reader from town to town. So not only is it when I go downtown on Kansas Avenue, but as I pull into my subdivision or exit off the county blacktop in some instances. But there was a point in time where maybe each one of those things individually didn't create a problem. But when you think about all this information that can now be funneled directly to a law enforcement agency or anywhere else that wants it, we have these AI tools. Can you talk about the totality, of surveillance that's being placed on citizens today?
I think that you are hitting the nail on the head with that question, because that is the problem with having all of these different tools and techniques. So law enforcement is correct that there are some cases that say, if a law enforcement officer sees something from a public vantage point, that may not be considered a search. And I've included a bunch of law review articles that talk about this. There is this thing that courts are considering called the mosaic theory of the Fourth Amendment, which is exactly what you're talking about, which is the government can now use all of those data points to see where you are going and who you are talking to. And this issue came up in a case I litigated during COVID, where you could see if a person was going to a doctor's office or then their lawyer, how much time they were talking to their doctor, how much time they were perhaps talking to their lawyer. And so under that mosaic theory, that is a violation of someone's objective expectation of privacy, because now you're able to track that person from point A to point B over 30 days or 60 days. And I think that is what turns this into not only a Fourth Amendment search, but an unconstitutional one. And one other point, I think that we have all talked today about the Fourth Amendment. The Kansas Constitution has Section 15 of its Bill of Rights. It currently is interpreted in lockstep with the Fourth Amendment, but I think that there are very good and solid reasons why, under the Kansas Constitution Bill of Rights, more protections should be afforded to Kansas citizens, and I predict in the future that is how the Kansas Supreme Court will indeed rule.
Thank you, Mr. McRoberts. And then I'll have one final question. I think I'll go with Chief Atterbury.
Darrell Atterbury with the Kansas Association of Chiefs of Police.
Thank you for being here, Chief Atterbury. Appreciate your perspective as always. Given the last answer about sort of the totality of things that are out there, I appreciate the court precedent that you and your colleagues have brought up about, if you're in the street, you can see it, but, nobody's sitting on top of a pole for 24 hours a day watching everything that happens. So I understand why that's allowed, but at the same time, it is sort of fundamentally different. From an opponent's perspective, how would you sort of balance the concerns Mr. McRoberts has raised, right? Because this balance between liberty and security, right? It's been in tension from day one. How do we work through some of those tensions?
We don't have that much time. No. We use it as a force multiplier because we don't have that person available to watch full time. And even when we do put people in that position, if I understood your question correctly, if we put them in a position so they could watch long-term, they still have to take restroom breaks, go get something to eat, and so on. So the cameras that we use, poll cameras, that's a force multiplier so that we don't have to extend a lot of person time to accomplish that goal, to try to weed out criminals, because this isn't for your general public. Yes, your license plate readers, they collect information, but for instance, the flock system, that information's dumped every 30 days. Okay, and then it's not accessible to us. So we look through that information so that we can find that one criminal that we're looking for who just committed a crime, who we need that investigative lead for, and then we pull that information, and the rest of all that is gone in 30 days from the time it was taken. So that is, I hope, addresses part of it, what your question is, but it's trying to strike a balance. I think the courts should do that, and I think they have done an excellent job over time, because you all know that if there was a library, it probably couldn't hold all the Fourth Amendment cases that have been heard and litigated. And we rely on those landmark cases to create our policies and our regulations that we follow, so that we can do the best job that we can for you and the citizens we represent.
Thank you, Mr. Atterbury, or Chief Atterbury. Appreciate it. The chair would just indulge me. I just want to say I know there's been a lot of discussion on this bill from both sides, and I do appreciate the earnest discussion everybody's had already on this. I'm sure there'll be more, but I just want to thank all the conferees today for working hard and having open discussions on this. Thank you.
Thank you, and I want to reiterate that as well. Thank you for the discussions that have been being had from both sides of the issue. And with that, then, questions from Senator Corson.
Thank you, Madam Chair. This question is probably best for Captain Slaughter.
Thank you, Senator. Captain Casey Slaughter, Wichita Police Department, Wichita, Kansas.
Thank you, and thank you for being here. Are there any relevant police incidents where a poll camera would have been a better type of surveillance than another type of surveillance?
Probably the one that would best answer that question would be last year, just as we were working through the initial poll camera bill. We had a group of armed robbery suspects who essentially fled back into a neighborhood at a known drug house, and this was learned over a period of time through research. And officers, the block was too hot, essentially, to sit on, meaning was too friendly with the target residents, and the officers had to sit in undercover cars in plain clothes almost a full block away. There was a friendly resident to the target house who recognized that the officer was in an undercover car doing ground surveillance, came out, confronted the officer, started shouting at him, basically to out him as a plainclothes officer, and then he proceeded to go back and tell the target that the police were sitting outside of his house in a surveillance vehicle. The target then came out of his house and started firing shots at the officer in the undercover car, missed him, but one of the bullet strikes actually hit an occupied residence across the street. Nobody was injured, thankfully. However, that then turned into a SWAT call-out, which any SWAT call-out involves 20 to 30 officers showing up, including the beat officers that were already there. So now you're talking upwards of 40 to 50 people and supervisors on scene. They ended up having to, over the course of hours and hours and hours, they ended up throwing tear gas into the house, and eventually he came towards the door. I think they had to use a beanbag shotgun, less lethal shotgun, and he complied and finally came out peacefully. I would argue that all of that could have been potentially avoided with a well-placed poll camera in that block.
Thank you for that. And are there, this would be for any conferee, are there specific examples where the use of poll cameras have been abused in the state of Kansas?
Yeah, not to my knowledge, no. Is it possible abuse could occur? Certainly, I'd be the first to admit that. I think we have to be transparent about that. But I think accountability measures exist. There's civil liability. The officer can be disciplined or fired. They can lose their C-post license through Kansas. The evidence can be suppressed through a court. And so there's various things. In fact, the officer can be charged under current criminal law through official misconduct. So we've got those accountability measures and those guardrails in place.
And then my last question, Madam Chair, is the mosaic theory that was described, that has not, to my knowledge, been adopted by the 10th Circuit as binding case law in the 10th Circuit. Am I correct about that?
Yeah, not to my knowledge in the way it's been explained anyway. And I could actually kind of answer that because I brought a little bit of a case law with me in the case it came up. And I highlighted a section, if you don't mind me reading just this small sentence. Cutting edge technologies will eventually and inevitably permeate society. In turn, society's expectations of privacy will change as citizens increasingly rely on and expect these new technologies, and that's Tuggle v. U.S.
Yeah, I appreciate that. I know we're not debating the bill, but I would just say that I think Kansas is going to be a much less safe place if we start making public policy based off of fringe legal theories. So thank you, and thank you, Madam Chair.
Thank you. Appreciate that. Let's remember decorum in our debate here. And Senator Shane, and then Senator Bowers.
Thank you, Madam Chair. And I'm going to pose a question, and I think I'd like one proponent and one opponent to come up and answer the question. You know, as I've looked at this in my lifetime, which has been much shorter than Senator Reichman's, you know, I've seen, you know, we've observed what folks would refer to as an Overton window, where something has gone from unthinkable to being policy. I remember as a child, the United States widely criticizing the United Kingdom for the CCTV systems and constant surveillance. And I'm fearful that what we're hearing is that what our citizens should expect is not an expectation of privacy, but an expectation of surveillance from the moment that they exit their home. And I'd like for you to address that concern of an Overton window shift, of going from something that was unthinkable to maybe something that is policy, and how we really deal with that from a policy basis. And kind of as a follow-up, it was mentioned, you know, we couldn't practically have a police officer sitting on poles on every corner. I would think that if we did have a police officer sitting on poles on every corner, we would call that a police state, which is also not what we want in the United States. So if one proponent and one opponent could address those thoughts and question, that'd be great. Thank you.
Morning again, Jeff Easter with the Kansas Sheriff's Association. Completely understand where you're coming from. The fact that it's more so the big brother theory that had gone on in the 80s and the 90s, which really wasn't anywhere close to where we're at now with all the camera systems. And so I understand why the committee is looking at how do we balance this. The bigger issue here for us in law enforcement is we do have the technology now to solve crimes in real time. I worked for the Wichita Police Department for several years. During those years, we had homicides were out of control. We were solving less than 30%. Now they solve 100%. So the fact of the matter is, I understand the police state, but the citizens themselves have bought cameras to keep the criminals out of their house or to catch the criminal that's breaking into their house. And so it is a delicate balance, but I'm not sure that this is the exact way to go. You know, from a standpoint of maybe some more accountability when it comes to law enforcement and the way we utilize this technology, I understand that completely as well.
Sam McRoberts, Kansas Justice Institute. The concern with pervasive government surveillance and warrantless searches was the very reason the Fourth Amendment was written. And in 1761, James Otis argued in Paxton's case for 6 to 8 hours that warrantless searches were violating a person's fundamental right to liberty and their natural rights. And there are so many cases that talk about that's why we have a Fourth Amendment, was to prevent the government from conducting warrantless searches of individuals, of their property, of their businesses. That's why we have the Fourth Amendment. And law enforcement is correct that sometimes courts have eroded those rights over the years, but that's why this bill is so important.
Thank you. Next, Senator Bowser.
Thank you, Madam Chair, and let me thank all the conferees today. I enjoy being on this committee because we hear such great stuff here. I think my question's for Mr. Stewart, please, Executive Officer, Kansas Bureau of Investigation. Mr. Stewart, I think the challenge that we have is, how do we balance our support for our law enforcement while at the same time weighing the constitutional rights of our citizens? I've got just a couple of questions here. How did we arrive at the 30 days? Why not? Because I'm pretty sure I heard Captain Slaughter say some of his investigations might run a year. How did we arrive at 30 days? Why not 6 months? And I think I understand that after every 30 days, you'd be required to get a new warrant. And then finally, I'm hearing law enforcement say that this is not really necessary. So I guess my final question would be, why are we doing it if it's not necessary? Thank you very much.
Bob Stewart, Executive Officer with the KBI. Madam Chair, Senator, I'm not quite sure where the 30 days came from. I think it was part of the drafting process, and the bringer of the bill would have to probably articulate the 30-day period as the reasonable standard that they used. I know that generally speaking, when we talk about not necessarily with poll cams, but with a lot of the other electronic techniques that we use, like wiretaps, it is very typical that we have authority for a certain period of time and we have to go back to the court and get an extended period of time, a re-up, they call it. So it fits the standard sort of way we think about using complicated technology. Could you remind me your second question, please?
Yes, and again, thank you for that answer. And I think what I'm hearing law enforcement say today is that this bill is not really necessary. If it's not necessary, why are we doing it?
I think it's a matter of going back to Senator Titus's question about your review and oversight. Certainly, we would all argue that the courts have pervasively ruled in this area, and we believe we have a very fair understanding of what the courts, both at the state level and at the federal level, want us to do. It's certainly within this body's purview to look at that and determine if stricter standards should be met.
Thank you. Senator Haley.
Madam Chair, thank you. And thank you, Madam Chair, first, let me say, for your hearing this crucial matter and having a hearing on this bill. I'm appreciative, and I don't know if I have a question for the proponent or opponent. I do want to know, as was raised by the neutral conferee written, is specifically what kind of equipment we're talking about. Let's assume it's just a camera, a basic camera, but no more expansive than that in terms of what is, quote, law enforcement equipment. And secondly, as we roll from that, because I know our time is short in this discussion that I think was raised by this Orwellian view that is now mainstream, that was once not even imagined that we would be in a society that had, from the moment one could leave their home, streamless surveillance, if you will, of their activity, to what is now commonplace. I remember this discussion about ag lands, Madam Chair, that there would be cameras placed, and I don't know if anyone else was here on the committee, where they could only place a camera, the rangers or our law enforcement could, for so much time to limit poaching on our ag lands. And I don't remember what resolution that we reached. There could only be a certain amount of time and a certain amount of equipment without there being some rolling new warrant or enforcement along that line. Finally, the equal protection and application question here. I imagine, I shouldn't be paranoid, that there are only certain areas or certain parts that will have increased surveillance. And if there could be in those areas private homes or poles or what have you, full disclosure, I'm a member also on the board of a utility in Kansas City. I sit on their board. And why don't you use, or you could, certainly private entities and homes, even those that have access to Ring doorbell cameras or what have you, again, private use to augment that. So again, I wanted to throw out just some of those thoughts and observations. I don't know if there's a question in there somewhere, Madam Chair. I'm grateful for this discussion and this hearing and the many thoughts, both pro and opposition that they've raised.
Thank you. And to follow up on the point that you raised, Senator Haley, KSA 32-1055, if the revisor could speak to that for a minute, where the legislature just a couple of years ago, I think, specifically required if the Kansas, the game warden was going to place a surveillance camera somewhere on a tree or on a fence to surveil, I think it is private land, they have to have a search warrant.
Thank you, Madam Chair. So KSA 32-1055, that was put in place in 2022. Essentially, it says that no employee of the Kansas Department of Wildlife and Parks authorized to enforce our laws under 32-808 shall conduct surveillance on private property unless authorized pursuant to a lawfully issued warrant, court order or subpoena, the Constitution of the United States, or one of the following exceptions to the search warrant requirement, which is exigent circumstances, consent searches, or the plain view doctrine. Those were taken specifically from Fourth Amendment case law, so that mirrors the Fourth Amendment somewhat consistently, and then it does provide a definition of what surveillance is.
Thank you. And I have just a couple of final questions, I suppose. And it might be best directed to the ACLU person who's here. We've heard a lot about cameras placed where you can lawfully stand and observe, and we've heard a lot about, well, law enforcement cameras versus private Ring cameras, so people expect different things now when they leave their front door. Could you just very briefly talk about the fundamental difference between a stand and observe at street level, eye level, versus stand and observe 24/7 without bathroom breaks from 30 feet above the ground on a pole, and then the difference, the fundamental difference between law enforcement cameras versus a private person's Ring camera?
Thank you for the question, Madam Chair. I'm Logan DeBond with the American Civil Liberties Union. To address your first question, what I think was the first question there, the difference between someone, like you said, being stationed there 24/7 and these, I guess, surveillance cameras in whatever form they're in is not only the range, but also we recognize the need for public safety here. I think that's important to point out. Why we are a proponent of this is this is simply putting a safeguard on this. This is saying, hey, this is okay. We recognize there is a need here. This is simply asking for a warrant to be in place, putting that additional safeguard there and saying, this is what we're doing, this is what we're after. We're limiting the scope to this one person, place, individual in particular.
Thank you. And then it's different when it's an observance from law enforcement versus a private citizen.
Yes.
Yes. Okay.
Yes. And I think that's where the warrant piece comes into play here as being so important.
Okay. Thank you. And I was remiss and I didn't see that we had a question from Senator Hill before I asked mine. So Senator Hill.
Thank you, Madam Chair. A real quick question, and it could be because I haven't really been around this process a lot, but probably to one of the Wichita people. The public utility poles, what ground, are they only situated on public ground, or are utility poles that are on private ground also subject to the use of surveillance cameras?
Yes, sir. Jeff East with the Kansas Sheriff Association. That is the difference between private property and public view. Utility poles that are on public easement, the right-of-way, that is public property. That's the only way that we can put up cameras because it's on public property. If there's other poles that are on private property, we cannot do that.
Okay, there's a difference between an easement and property ownership. The easements would, of course, be subject to the terms of the easement, which would have been written in most cases many years ago. Do those easements have provision for surveillance cameras to be part of the easement?
Not that I'm aware of. There's no laws that I'm aware of that talks about easement. The most recent law that was passed was a year or two ago in reference to utilizing those utility poles that are on the public right-of-way, which is those easements. That's the only law that I'm aware of.
When you say public right-of-way, is that, I mean, I live out in a rural area, so it's a little harder for me to understand, but our public utility poles, or the utility poles that are there, are actually on private property with a utility easement.
Correct.
Would those areas be subject to putting a camera on?
Yes.
Even though the easement has no provision in it? When the person signed the easement, they did not sign the provision to put cameras on there.
Correct. So the cities and the counties have easement in each one. I'm sure where you live, there's an easement as well. And so public utilities can come in on those easements and put up poles because it's a public easement that they are able to use, or a easement, and it's public right-of-way that they're able to use those on.
Thank you for your answers.
Thank you. Well, all right, Senator Rose has a follow-up question too.
Thank you, Madam Chair. This question is for any of the opponents. The way I understand this bill, you can place a camera on a utility pole for 30 days. And during that 30-day period, you can go to a judge and you can ask for a warrant or a court order or a subpoena. I don't understand the hardship in that process. So can you explain to me how that will restrict you from going after crime?
I'm sorry, can you repeat Jeff Easter with the Kansas Sheriff Association. Can you repeat that question, please?
Yes, sir. Thank you, Chair, and thank you for your service as well. The way I understand this bill, you can put a camera on a utility pole for 30 days. And during that 30-day period, you can approach a judge and explain the situation to the judge. And the judge can lawfully issue a warrant to extend that camera beyond 30 days, or a court order, or a subpoena. So can you please explain to the committee what is the hardship created by this for law enforcement in combating crime?
Yes, sir. So that's not the way we read the bill. The way we read the bill is we're not permitted to put a camera up without a search warrant, subpoena, or court order. So we cannot put it up for 30 days and then go get a search warrant, court order, or subpoena. It says public utilities shall not permit, allow, or enter into an agreement that authorizes a law enforcement agency to attach, access, operate, maintain, or remove law enforcement equipment on any utility pole or other structure that is owned or operated by the public utility for more than 30 days unless we get authorized by a lawfully issued warrant, court order, or subpoena. That's the way we're reading that.
Thank you. I think if we could have the reviser clarify, I think the bill proposes that up to 30 days, you can place the camera without the warrant. But beyond that, then you have to prove to the court for a subpoena or an order or a warrant that you have reasonable suspicion and other things to keep the camera there. Madam Reviser.
Thank you, Madam Chair. Yes, so if you, start out on line 10, a public utility shall not allow the law enforcement agencies, and then you go down to line 13 and 14 for more than 30 days and less. So they could enter into an agreement that allows them to put that pole camera up for 29 days. And then in that meantime, if a warrant was acquired, then they would fall under the exception because they're authorized by a lawfully issued warrant that would allow them to keep it up past the 30-day period.
Thank you. Appreciate that clarification. So with that, then, I think that concludes our questions. Again, appreciate every conferee's attention and testimony today, and that our opponents and proponents have been, I think, talking together. I'm not for certain, but would appreciate that. And committee, we are not scheduled. I want to then close the hearing on Senate Bill 373. Committee, we are not scheduled to meet tomorrow. However, next week and the following week are our last 2 weeks to have hearings. So we will be meeting Monday through Thursday, and Friday will be on call of the chair. So just be ready, and we might need to go a little bit past our aim for getting out of committee at 11:30 goal some of those days. So appreciate everyone's attention and work from the committee staff and those following along in the committee room and online. And with that, then have a good weekend, and we